Good morning. We are going live. It's great to have you here today. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. All right, I am taking a look at the questions we have online right now. All right, here's the first one. Why do some people only sue for $1? So maybe you've seen this before. Taylor Swift brought a lawsuit where she sued for only $1. Another case, Gwyneth Paltrow sued for only $1. Now, she added a request to reimburse her legal fees on top of that as well. But why would people do that? Why does that make any sense? Because if they have a basis to bring a lawsuit, they could probably ask for a lot more than $1. $1 is just so small. It's like, why would you even spend the time and effort bringing a lawsuit? There must be something more happening there. What is the legal strategy? I think it's quite simply this, that these people are trying to demonstrate that they're not money hungry, that they're not trying to bully somebody else. They are simply trying to make a point on principle that they are right and the other side is wrong. And they're asking a court to rule in their favor to send a message to the public. That's why you often see these types of requests by celebrities. Most average lawsuits and average people do not sue for only $1. In my mind, it is a principal position, or it's a public relations type strategy. It is not something that's legally significant, except to say, hey, I won. I got what I was looking for. And by the way, when you win, you may have a right to recover your attorney's fees. So if you set the bar really low, we're asking for $1, we got $1. Now that we won, you can ask for attorney's fees sometimes. Why do I say sometimes? Because in the United States, it's called the American rule. The default is you are not entitled to reimbursement of your legal fees if you win. The only times in the United States you are entitled to reimbursement of your legal fees is if a contract or statute or some other law or rule permits you to. So the default is you cannot recover your legal fees if you win, but you can recover if a statute or some other law or a contract allows you to do that. So many contracts say the winner has a right to recover attorney's fees. By the way, you may be able to still recover your court filing fee, perhaps even some of the other fees that you had associated with serving a lawsuit, maybe even experts. But you are not allowed to recover attorney's fees unless a statute, some other law or rule, or a contract allows you to. So, why do people sue for $1? It's simply to take a stand on principle, or perhaps make a public relations statement that they are right, they have won, but it's not about the money. Next question. Can I work for someone who has signed a non-solicitation agreement with my employer? All right, so this is actually a question from an employee, not an employer. I usually represent employers, but sometimes I represent CEOs and other company leaders, and they may be an employee who didn't sign a non-compete agreement or a non-solicitation agreement, but their employer may have. So here's the setup. The employer has an employee, and that employee signs a non-solicitation agreement. What that means is if the employee leaves for a period of time, the employee will not solicit other employees or customers or others part of the business. So that employee leaves. Now that employee starts a new business competing with the employer. And that's okay because we're not talking about a non-compete agreement. A non-compete agreement says you can't compete. But the employee didn't sign that. The employee signed a non-solicitation agreement. That says, I will not solicit employees or customers who are working with the business, but still can compete. So that employee leaves and starts competing with her former employer. So as she's working and building this company, competing with her former employer, now she decides she wants to hire a, an employee from the employer who's currently working for the employer. And that's the person who's asking the question. So he is asking, can I go? I haven't signed a non-compete or a non-solicitation. Can I go work for my former coworker? She's building a new company, but she has signed a non-solicitation agreement. Is that okay? The answer is no. You cannot, even though you have not signed it. And here's why. She signed the non-compete agreement, or I'm sorry, the non-solicitation agreement. Because she signed the non-solicitation agreement, she is not allowed to employ you. And so if she did, she would be breaching her contract with her former employer. And if you accepted that employment, you would be interfering with that contract. Whenever your work with somebody would result in that person breaching a contract, you are deemed to be tortiously interfering with the contract. Tortious interference means although you have not broken a contract, you have interfered with a contract in a way that is illegal. Your participation with a relationship has resulted in a breach. And if you know of that, then you are liable for tortious interference. Let's break that down for a second. Tortious comes from the word tort. Tort is a type of legal claim. What are other torts? Negligence, assault, battery, conversion. There are all sorts of different torts. One of them is tortious interference. And that basically means that you are unlawfully interfering in another contract. So, to summarize, if you want to go work for somebody who has signed a non-solicitation agreement with your current employer, which says she cannot employ your current employer's employees for a period of time, then you cannot go work for her until the term expires in the non-solicitation agreement. You would be engaging in unlawful activity, and even though you signed no contract, somebody else signed that contract, the person you want to work for. You cannot legally go work for them. You might say, what happens if someone violates a non-solicitation agreement? Let's walk through that question. Imagine you have a non-solicitation agreement between an employer and a former employee. So the employee was working with the employer and then left and started her own company. She signed a non-solicitation agreement. Now let's assume she hires one of the employees or one of the customers of her former employer. In some way, she breaches the non-solicitation agreement. Assuming she does, what happens next? The employer can sue the employee who left and the person who is now working for her or working with her. So now I should clarify something. If an employee goes to the new employer and that employment violates the non-solicitation agreement, the employee is only liable once they know of the violation or once they know that their working there is a violation of the non-solicitation agreement. If you don't know, you're not liable. So, what usually happens when an employee is hired in violation of a non solicitation agreement is the employer sends a letter, a cease and desist letter, to the new employer and the employee and says, this relationship you have is in violation of our non solicitation agreement. And you must immediately cease and desist unlawful activity. That is, activity in violation of the non solicitation agreement. So, usually, there's a cease and desist letter sent first, but not always. The employer doesn't have to send a cease and desist letter first, they can just sue. But usually, because of the expense and time involved in a lawsuit, a cease and desist letter is sent first. That's much less expensive from a legal standpoint than hiring an attorney. And it gives both of the parties an opportunity to change their behavior and comply with the non solicitation agreement. If they refuse to comply, then the employer needs to decide, is it worth suing? Many times, then, the employer will, in fact, sue. So, what happens if somebody violates a non solicitation agreement? Usually, there's a cease and desist letter sent first, but it's not required. And then, second, the employer, the former employer, can sue both the employee who left and the new employer for breach of the non solicitation agreement. All right, let's take a look at the next question. How do, or let's put it this way. How do lawyers handle a case if they are certain to lose? I've had this before. I've had clients come to me and I look at their case and I tell them, you've been violating the law. You are certain to lose. Now, my job is to make sure they don't get railroaded, that they don't get overwhelmed and get a worse consequence than they should. But I am also thinking through strategically. Is there a way to shorten this process and come to a compromise and a resolution? There's kind of a funny old adage among lawyers. If you have the facts on your side, pound the facts. If you have the law on your side, pound the law. If you have neither the facts nor the law on your side, pound the table. I actually have a case like this right now where we are in the right. The other side is totally in the wrong. And the lawyer on the other side has not been willing to participate in a discussion about the facts, nor a discussion about the law. Instead, all he is looking to is any little nitpicky thing that can be argued about. In fact, I'll give you an example. We scheduled a meeting for a first thing in the morning, and the lawyer spent a good portion of that meeting talking about how we were engaging in bad faith by trying to schedule the meeting early in the day, knowing that he somehow would have difficulty attending that meeting early in the day. We spent 10 to 20 minutes sitting and talking about why the meeting was scheduled at that time of day. And by the way, He could have simply said, "Hey, let's do it at a later date." And we told him that. But he was going to sit and pound the table because the facts and the law are not on his side. All right. So that's not my style. I don't find that helpful. I think any good attorney can see through that tactic and starts getting confident, like, all right, we've got this case. Usually, what I think makes more sense is to talk about settlement, acknowledging that before we get into all the facts and the law, it's going to take a lot of time for all the parties to review all the evidence. There's a process everybody needs to go through. In the meantime, the parties are spending a lot of time on attorney's fees. The parties are distracted from other productive parts of their lives. And in the interest of avoiding all of that wasteful effort and litigation and expense, maybe we should talk about what does it take to look like a win-win here. Sometimes it's said to avoid the costs of litigation, what would it take to just settle this case? I've had a number of cases where the parties really didn't want to spend enormous amounts of money. The parties didn't want to waste the time and expense required to go through a lawsuit and get to trial. And so, as they are looking at this big potential case, they said, you know what? Let's see if we can work out some resolution that lets us both move on with our lives. Let's face it, a lot of times parties can make much more money and financially come out better ahead if they focus their time and money on growing their business, bringing in customers and sales. Instead of spending money on lawyers, spend the money on advertising and growing their company. So a lot of times, financially or from a math perspective, business owners are far better off not fighting in litigation. But what they many times will tell me is they would rather spend the money fighting than on their business because they are so angry. They have so many emotions. This is an injustice. And so, one role I have as an attorney is helping business owners think about what matters most to them and what is meaningful and what makes the best long term sense for themselves. Um, Sometimes I have talked with business owners about the emotion of this and fighting for justice, and that sometimes it's better to just let these people go and move on with your life and do what's better for you, your business, and your family. And my clients have started to wonder, do I have concerns about the case? Is there a reason I'm trying to talk them out of it? Why would a lawyer who could make a lot of money fighting in a case be trying to encourage a settlement? I'll tell you why. Yeah, there are a lot of lawyers who would love to milk this thing. And in fact, I think that's a real problem in the legal industry, that we have lawyers who have a financial incentive, and a large one, to continue to fester and fight and fan the flames of emotions so that they can keep billing on the case. But ultimately, that's not why I went to law school. That's not why I live. I think that's a very sad life to be in, to have clients entrust you with their future and looking out for their best interests, and then to instead put your interests first, trying to benefit financially as a lawyer while driving your client through the ugliness and the toxicity of a lawsuit. It's a miserable way to live. I couldn't go to sleep at night if I did that. I don't know how attorneys live that do that, but I'll have nothing to do with that. For me, if I can serve my clients and help them do what's best for them, I believe that is a very rewarding way to practice law. I also think in the end, whether you want to call it karma or what goes around comes around or whatever your philosophical view is, I think we're better off when we we try to do what's right rather than what's in our self-interest. So as it relates to my clients, I often spend time talking with them about what is the real cost of fighting? What's the distraction from your business, the emotional cost, the negative, the impact of the negative thinking on their daily lives. A lot of clients tell me that litigation is so stressful for them. It's affecting the relationship with their spouse. It's taking away time from their kids. It's taking away time from their hobbies. It's taking away time from their customers and their team and their employees. All of those are very real costs for a business owner engaged in litigation. And when we add those up, it often makes sense to be very serious about what amount of money could we compromise to make this lawsuit go away. So whether we have a great case or a losing case, we have to look at the real costs of litigation and the distraction of a dispute. And then sometimes, if both parties are reasonable, a resolution can be met. By the way, a lot of times both parties are not reasonable. You might have a bully on the other side. And I encounter that maybe 20 to 30% of the time, where the case just isn't going to settle because the other side is either irrational or there is some other economic influence on the deal. What might that be? Well, let's say you have two competitors and they know that if one ties up the other in litigation around technology, they can't use that technology. And as long as that case goes on, one competitor has more time to get ahead because the other one is stifled by not being able to use that technology. That's a very frustrating aspect of litigation. Businesses use litigation strategically to hold back competitors. And if you're an attorney representing a competitor who is being held back, it's often going to be your job to call that out with the judge and reveal this unfair competitive tactic that's being used. Litigation is not supposed to be used to simply hold somebody back. The justice system does not like being manipulated for competitive purposes. The justice system is supposed to be working for justice. So that gives a lot of tips and techniques and insights into the mindset of attorneys who need to handle a losing case. And how do they think through that, and how do all sides manage that? If you're interested in other educational content like this, feel free to subscribe to this YouTube channel. That way you'll get notices about other times we go live and other videos that come out. We're trying to produce regular educational content so that business owners can be empowered to have a more successful business and more successful life. So go ahead and subscribe to the YouTube channel if you find this helpful and you'd like more videos like this. Next question. If a power of attorney and healthcare directive conflict, which one prevails? Let's talk about what both of those are. A healthcare directive is sometimes called a living will. It is a legal document recognized under state law that allows a person to designate someone else to make medical and healthcare decisions for them. So, for example, if a person is unconscious or under drugs, affected so much by the drugs in a hospital that they're not able to make decisions for themselves, the person they've designated in their healthcare directive or living will can make those decisions for them. So typically, a healthcare directive is put on file with a hospital. For example, when I went and had surgery, the hospital asked me before I went in for the procedure, do you have a healthcare directive on file? And if not, Would you like to get one? And some hospitals even have a little form where you can fill out who's in charge of any medical decisions while you're under if decisions need to be made and you can't provide guidance to the doctors. What might those decisions be? For example, let's say a doctor gets into an operation and finds uh, a spot of cancer and believes it should be removed, but removing it would also have some risks. The doctor doesn't want to make a decision herself. She would like to consult with the patient, but the patient is under. The patient is in surgery. The patient can't comment. If the patient has designated someone to make those healthcare decisions in a healthcare directive or living will, the doctor can explain the risk to the agent in the healthcare directive, and the agent can make the final decision. Okay, so what is a power of attorney? A power of attorney is very similar. It's where one person designates someone else, you could call them an agent or an attorney in fact, and that person can make decisions for someone if they can't. So, for example, a power of attorney might be used if you are traveling to another country and you need to designate somebody who can sign legal documents in your country while you're gone. Say, for example, you have a real estate sale coming up or a closing, and the closing is going to happen while you are traveling outside of the United States. Let's say you're in Europe. You are not going to be present in the United States for that real estate closing, so you can't sign the documents. What can you do? You can have a power of attorney to designate a spouse or a real estate agent or an attorney or a friend to sign those real estate documents for you. That's the purpose of a power of attorney. So the question here is, what happens if a power of attorney conflicts with a healthcare directive or living will? First off, usually that doesn't happen. And here's why. The power of attorney is for legal and business decisions. The healthcare directive is for medical and healthcare decisions. By the way, sometimes a healthcare directive, or sometimes called living will, is called a healthcare power of attorney or medical power of attorney or power of attorney for healthcare. But let's say hypothetically, somebody has signed a healthcare directive that appoints one person to make decisions for their medical decisions. And they also sign a power of attorney, which covers that same decision. Maybe it says medical decisions, or maybe it says financial decisions, and the decision that needs to be made has a financial component and a medical component. So that is the question we have here. How do we resolve the fact if they conflict? Usually, so first off, it's a mess. It's not real clear. But usually what would happen is the person who was appointed most recently would have the authority to make that decision. But I'll acknowledge that if the older document did not expire and that person wasn't replaced by the new document, we admittedly have two people authorized to make the decision. That means they can both make the decision without consulting the other. So often hospitals will, as a practical matter, will simply rely on the decision made by whoever they're talking to. They may not even know there's another person out there to make the decision. Now, what happens, though, if both, we'll call them agents, who have been empowered with making the decision, tell the doctor to do the opposite? What happens then? Well, that is a very difficult decision for the doctor. If the doctor asked me what to do, I would say, you are in a legal quandary and you're going to have to make the best decision you can because you don't have clarity regarding what the patient wants. Now you might say, but Aaron, didn't you just say that the most recent power of attorney or document prevails? I did, but in a scenario where a doctor is being told two conflicting decisions or choices about a decision, and both of those people were lawfully appointed to make the decision by the patient who is unconscious or unable to make the decision, I believe legally the doctor does not have clear direction regarding the patient's intent, and thus either needs to get a court to make that decision, or the doctor needs to make the decision herself. So this is messy, and if you find yourself in this position, I'd recommend contacting an attorney. I've actually seen one similar scenario like this, and ultimately there was a effort to get a court to make a decision. A lot of times courts have a process where they have a judge who is on call to make emergency decisions. And you file papers with the court for an emergency action. Sometimes it's called an emergency TRO or temporary restraining order, where one party is trying to restrain another party from taking action contrary to what they want. So if you're in this position, you can try to negotiate with the doctor or whoever's making that decision. If you're not getting your will, then you may need to immediately seek an emergency TRO from a court. All right, let's take a look at the next question. Do I need a potential manufacturing partner to sign an NDA before I disclose a product design? Here's the scenario. Imagine you came up with a great product design. You would like to talk with some potential manufacturing companies or some manufacturing companies who would potentially manufacture your product. You want to disclose your product's secret information to the manufacturer to see if they have the capability to design that product. Should you have the manufacturer sign a non-disclosure agreement, which is known as an NDA? Yes, you absolutely should. A non-disclosure agreement, which is sometimes called a confidentiality agreement, is a contract that says once information is disclosed to the other side, they can't disclose it to anyone else. And it probably also says they can't use it for any purpose other than to help you. I think that is a very valuable conversation and document to have signed. Because if you don't have a non-disclosure agreement signed, that manufacturer can take your idea and run with it or share it with a competitor of yours. So it's really important if you are going to share a design or any confidential information with another company that you have them sign a non-disclosure agreement, which is also called a confidentiality agreement. You might say, but a lot of companies won't sign an NDA. For example, let's say you went to Google and you said, hey, I have a great idea. I'd like you to sign an NDA before I present it to you. Google will usually say, no, we're not signing an NDA, because if we do that and we are already working on the idea, you may sue us later for rolling out that idea. We don't want to have the risk of you sharing an idea with us that Google is already working on. And then we now are under threat from a lawsuit from you because we came out with this idea. I've actually been approached many times by people who came up with some great ideas, and they presented those ideas to a large company. And then the large company later rolled out that idea. And when there is not a non-disclosure agreement, it's much harder to claim that the company did anything wrong by running with your idea, because you can't have a copyright around an idea. You can't have a trademark around an idea. You can have a patent around an idea, but you need to make sure that you have gotten that patent. So if you are interested in patenting an idea like a process or a recipe or a design, you will want to talk with a patent attorney about that, and at a minimum, get an NDA signed by anybody who you share that idea with. One warning, if you have an idea and you share it with somebody, the general rule is that you now have 1 year to get a patent, or you can never get a patent for that idea. So once an idea goes public, generally speaking, you have 1 year to get a patent or at least file the application. And if you wait for more than a year, you lose the rights to that idea. I'm looking at the next question here. All right. So to those people who are wondering, how can I get access to the exclusive educational videos that I've put out online that are not available publicly? So they're not available on YouTube or any of our other social media platforms. How do you get access to them? Go to aaronhall.com/free, and that's where you can sign up to get access to those videos. There's no charge. And that is a series of educational videos that I've put out helping business owners avoid the biggest problems I've seen in over 10 years of practicing as a business attorney, so that you don't have to go through the problems and the expense that many companies do when they don't understand how to avoid those problems. So aaronhall.com/free is where you can get that. Is your money in Venmo or PayPal safe if the companies go under? So the short answer is probably not. If you put money in a bank, that money is generally secured under the FDIC. That is the Federal Depositors Insurance Corporation, I believe is what it's called. Basically, that is a government program that says if banks go under, a significant portion of your money, for example, $250,000, is protected in a bank account. The government will guarantee that or insure that. But is your money safe in PayPal or Venmo or one of those other accounts? The answer is no. Those accounts are not protected by FDIC. The money that you've put in there currently under law is treated as a loan essentially to that company. And if those companies went under, so like if Venmo became insolvent and dissolved and terminated, you would have a claim as a creditor or as a lender to that money. But if there's no money left, you're not going to get paid. Likewise, with PayPal, any money you have sitting in your PayPal account is essentially a loan to the PayPal company. So your money sitting in these money transfer companies is much more at risk than if it were in a traditional bank, which is regulated by the federal government and protected by FDIC. So I recommend people not leave a lot of money in Venmo and PayPal accounts for this reason. I'm not aware right now of any reason that those companies would go under, but why accept that risk if you can put that money in an account that is FDIC protected? So putting that money in a bank account or some other secured account is far better than leaving it in a PayPal or Venmo account. Similarly, Coinbase, Binance, and other companies that are not banks and not regulated, at least at this point for cryptocurrency, money that's sitting in there is just like PayPal or Venmo. It's essentially a loan to that company. They're not banks, so there's no FDIC protection for your money. So if you are interested in protecting your money, have it in an account that is FDIC protected, not Coinbase, Binance, um, PayPal, Venmo, etc. Next question we have here. Which lawyers have the highest rates? How much do they charge? Well, we did a little digging online, and current rates appear to be as much as around $2,000 per hour. And typically, these are going to be lawyers who are in high demand, have extraordinary amount of experience, and are able to save a lot of money for their clients, which justifies why they are charging so much. So I've actually seen a little above $2,000 per hour or $20,000 per day. We'll put a link down below with an article that I put together on this, showing some online examples of what some attorneys make. Generally, what they charge. Generally, attorneys' rates are not public information, but sometimes they need to be filed in court cases to get reimbursed. And so we can see the rates that they are charging because these court cases involve public documents. And that is typically where journalists have been able to uncover how much are attorneys paying or receiving these days. By the way, the money that these lawyers are paid doesn't mean it actually, or that their firm is paid, doesn't mean it actually goes to the lawyer. It covers the firm's overhead, the firm's marketing, the firm's accounting department, the administrative staff, insurance, all those expenses that go along with running a company. Just like if you are a bakery and you sell $2,000 worth of bakery goods in a day, it doesn't mean the baker is taking home $2,000. What it means is the business brings in $2,000, which they now use to cover all the expenses of running a business. That said, $2,000 is certainly a lot of money, and it takes a very expensive problem to be able to justify spending that kind of money on an attorney. Let's take a look at the next question here. As far as making a will goes, would you recommend an online company like LegalZoom? Thanks for the question. And I see here that the question involves you might want to trust, you might want a will. What are some potential downsides of using a service like that? In order for a will or trust to be lawfully enforceable, it typically needs to be notarized and or signed by in front of two witnesses, and often both. So in other words, if you hire an attorney to draft your will, often two staff members from the law firm will come and serve as witnesses when you actually sign the document. And somebody may also notarize the document. So there's no dispute over whether you actually executed that will, whether you actually signed it. If you're using an online service, here are the potential problems. First, you still have to deal with this signature issue locally. And you are going to be responsible to make sure it's done right. And by the way, if it's not done right, you're probably not going to know until you're gone. And then it's too late to do anything about it. Similarly, when you are using one of these online services to put together a will or a trust, they are not lawyers. That's their disclaimer has a very strong disclaimer on that. They are simply a template service, and they can use software to help you identify the language that should go in that template, but they are limited by state laws that govern providing legal services. These software companies are not allowed to provide legal advice to you. In other words, they're not allowed to look at your situation and figure out what language should be in there. They can let you use their software, but they can't give advice on that. So if you don't have an attorney who's actually understanding your goals and your concerns and making sure that the language in the document you're signing, whether it's a will or trust, does what you want, you're accepting a lot of risk. And the real risk or the problem is you don't know what errors or wrong words or phrases or sections were used in that document until you're gone. I mean, I guess technically you don't even know at that point because you're gone. You've passed away. And now it's up to a court to try to figure that out. And a court is going to hear from all sides. And so now you have your family members or heirs lawyering up, spending money, fighting. And typically, the last thing somebody wants is for their loved ones to be fighting over what they get. You intended this inheritance as a blessing to their lives. You certainly would not want it to cause conflict, stress, and legal fighting. And yet, unfortunately, that's what happens when there are errors in a will or a trust. And I'm using the word errors lightly because usually you read the sentences in a will or a trust and they're perfect. The grammar's perfect, the spelling's perfect. The error is that the legal language does not do what you intended it to do. And so you can't see that error just by looking at the grammar or the spelling. It takes a person who understands all the legal terms and the legal doctrine and concepts to read it or craft it in a way that reflects what you've said you want. That's why right now, attorneys are the only way to do that. Artificial intelligence can't do that yet. Legal template services can't do that. So, and by the way, if you want a template, there are a lot of free ways to get a template. You can just type in Minnesota will template file type :PDF and take a look at some of the results that come up. Or New York trust template file type :PDF. When you drop that into Google, it will show you all sorts of PDF responses that match your search terms. So you can find all sorts of templates. But in most cases, I recommend that people not use a template service online like LegalZoom for a will and a trust because they're complex documents and there isn't enough time to correct it. You might use it for a simple contract. You might even use ChatGPT for a simple contract. But a will and a trust ties into state statutes and legal doctrines that are not necessarily simple. In fact, many times people are better off not having a will at all than having a will that doesn't say what they want it to say. In all states in the United States, there's a statute that says if a person dies without a will, that's called intestate, there are default provisions regarding how their assets are distributed. And a court oversees that in a probate process. So if you pass without a will, there are a lot of default provisions that work for most middle class or people who don't have significant money. For example, it says the default rules in Minnesota say if one spouse passes, everything goes to my other spouse. If both of us pass, everything goes to our kids. If our kids pass at the same time, or we don't have kids, it goes to our parents. If they're not around, it goes to siblings. So you have these default rules in place, but they don't apply if you have a will. And if you have a will that doesn't say what you think it says, then you find out your assets go to the wrong, or then the assets would go to the wrong people after you pass. So I'm not a fan of using an online service. One option, I suppose, if you're really trying to cut corners, is to use an online service to prepare your will and or trust. Or maybe you just go down to your local office supply store and buy some software for $50 or some templates and use that to put together what you think you want. And then hire a local attorney to review it to make sure it says what you think it says. And then that attorney and the attorney's staff can help you with witnesses and signing it and make sure it's legally given effect. Because a document that is not properly signed or notarized or done before witnesses is as worthless as any other letter or note that you may or may not have written, or somebody might have written for you. The reason the rules are so strict on wills and trusts is because the court wants to know it was actually you that put that document together, not somebody else pretending to be you. So that's why the state law is so tight on the signature requirements for a will. And in fact, many states will not even honor a video of you because it is not necessarily as reliable as the process that's in the statute. This is a hotly contested issue, but the concern is that a will, who knows what the date and time was of the will, or I'm sorry, of the video will. If a person creates a video and says, here's what I want done, did they have proper legal advice? Were they under the influence of any drugs? Was somebody holding a gun to them behind the camera? And what was the actual date and time of the video? There are all sorts of uh, credibility issues with video wills. And so, for that reason, to my knowledge, at least so far, most states do not even follow uh, or consider credible a video will. It needs to be a will signed as required by the local state statute. Okay, next question. Does having a will avoid probate? No. A will never avoids probate because a will is the instructions for a court in probate. A trust will avoid probate, but a will does not. And a trust only avoids probate if you have your assets in the trust prior to your passing. A trust is instructions for a trustee to handle everything that you've put in the trust before you pass. A will is instructions for a court to handle everything that you own, not in a trust, upon your passing. So a will never avoids probate. A will is the instructions for a court in a probate proceeding. Why shouldn't business owners call employees family? You might have seen this. It's been a trend for the last 3 decades to say, "Hey, we're like family." This is the ABC company family. We look out for each other. We care for each other by family. Why is that not a good idea? Because for two reasons. First, it sets up an unrealistic expectation in a relationship. And second, everybody has a different definition of family. If somebody had a difficult relationship with parents or siblings, they may not want to be in a relationship with someone else. a family relationship. So there, on the spectrum of what people think about family relationship, uh, there are people who have had very bad experiences in family to people who love their family more than anything, and those are the most wonderful people in their lives. So family means a lot of different things to different people. Also, in an employment relationship, it cannot possibly be like family because government laws apply and there is a financial component that will never exist in family. In a business, if businesses cannot pay all the employees' wages, they have to let the employees go. They're not allowed to just keep employees and not pay them. And so, but with family, you don't let family go. You don't say, hey, family, I'm cutting you off because I don't have enough money. The general view of family is family for a lifetime. And it's not a contract, it's not a temporary relationship. People are family members until they're passing. And that is a very different dynamic than what you must have in a business. A business is confined by financial restraints in a way that a family never will have. And so, practically, what does this look like? Well, I can't tell you how many times I have talked with disgruntled employees who have said, yeah, they said it was a family until money came up and then they had to let me go. Or I've talked with business owners whose hearts are breaking and they say, it's a family here. I can't let these people go. We always say we're as tight as family. We look out for each other as family. But my CPA is saying we don't have the money to keep them. I have to make that decision. And I feel awful. I feel like I'm betraying people. And you know what? The answer is they are. They are betraying those employees because they set up the expectation that they're like family and they never can be. So I think it's far more important to be precise and accurate in relationships and acknowledge we are aligned right now for a time. We have a shared interest in bringing success to a company and working together. There is great synergy here between these teammates in our company. But let's be realistic about those expectations. Let's be honest about them. And and I love to have conversations with people in advance to say, "Hey, look, if we're having some trouble, I don't want to just have to give you a 2 week notice. I want to give you a much longer notice." I had a I had a boss. I had two bosses in the same company. And with one of them, I was concerned that if I told him I was going to go to law school in the fall, that he would have just given me a 2 week notice or maybe even immediately cut me off. But I had another boss that I trusted, and it was just a wonderful boss. And I I went to him and I told him I'm looking at going to law school in the fall. I wanted to let you know now so the company can make arrangements for my replacement, but I'd love to continue to work here and I will continue to work hard my whole time here. He was so wonderful and gracious. He gave me some tips about going to law school. He encouraged me to talk to some lawyers and offered to make introductions to some of his lawyer friends. And I ended up working at the company until I transitioned to law school, and it was a great transition. I will always be grateful to that boss. His name is Tom, for the opportunity that I had to work with him and to learn with him. And he was an example to me of what a great, mature, thoughtful, and caring boss can be. And I always said, if I am ever in a management role, it's my desire to be able to have that sort of trust and relationship with employees. Now, if you've had some experience in management and employees, you know that statistically you run into people who can't be trusted. To as you work with somebody, you find out that they don't have that same degree of integrity and trust. And so I'm not suggesting that you can never or that bosses should work with every employee in that way because that would be naive. There are employees who are not trustworthy, and bosses need to be careful with them. And for example, if they're going to be let go in 6 months because the financials are not doing well, the boss may not be able to give that employee notice for 6 months because the employee may engage in improper activity with the company's resources, start taking things or bad mouthing the company or whatever, that the employee wouldn't respond in a good way. But where you have employees who are mature and reasonable, and you have a good, transparent relationship, or at least an open and honest relationship, I have seen so many times where I've been able to have conversations with those employees 6 months in advance, where for some reason it's not going to work to have them continue with the company as I originally had thought. Maybe dynamics change, maybe financials change, or markets change. And I have been able to remain friends with those employees today. They didn't feel disgruntled, they didn't feel resentful. And it's wonderful when you can have essentially an alumni of former employees of a company who speak well of that company. So I think all of that comes back to not calling people family, but instead being more precise about the open and honest relationship that you have, the alignment in your values and goals, um, and not setting up unrealistic expectations that this is a permanent relationship, which is what you have with family. All right, looks like we have gone over an hour. We have no further questions being submitted right now. So I am going to wrap this up. If you have a question that you'd like answered, feel free to put it in the comment section below. Or you can reach out and email me your question, and I will present it in a future video. I'd love to get your topics and your questions. So we're addressing the real questions that are on the minds of entrepreneurs and business owners. I'm Aaron Hall. If you'd like to stay in touch, go to aaronhall.com/free, and we will put you on a list so you can receive some free resources, including videos to help the success of your company. Thanks for joining us on this live video today.